How you doing, sir?
I'm good. How are you?
Good.
Our goal is still to bring Riley home.
At this point, there is no evidence that I'm aware of that would indicate foul play.
He's my best friend. He's everything.
It's been 2 weeks and still no sign of Riley's strain. So could hope be wavering? And 3-year-old Elijah Vu missing now for over a month. Could his mom or her boyfriend start talking? Plus, the latest on the case against defendant Karen Reed. Her lawyers are pointing the finger at some people who are saying back that they have nothing to hide. It's all coming up next right here on Opening Statements. A good Thursday morning to you, or should I say happy Friday Eve. Welcome to Opening Statements. I'm your host, Julie Grant, and just like in an actual trial here on this program, we're all about getting you all ready for what's ahead in the court day. I describe the show kind of like coffee in court. It's morning time. We get all warmed up together. So why don't you go ahead and grab that cup of coffee right now, because it's time for my opening statement. Who murdered Madeline Soto? Was it that filthy creep, Stephan Stearns? The defendant accused of a slew of child abuse crimes that was dating Madeline's mother. Was it him? Was it Stearns, the man police say had child pornography on his phone? Was it the man police say had been sexually abusing 13-year-old Madeline since she was 11? And if so, if it was him, how did he kill her? My friends, we may not have to wait long for those answers, because today at 2 p.m., the police in Kissimmee, Florida will be holding a press conference to announce an update to everyone who wants to see justice for beautiful Madeline. And I'll tell you what I'm hoping gets announced at the press conference based on the case evidence that I've seen. I'm hoping that sicko Stearns gets hit with homicide charges today. And I'm hoping that the indictment was done by a grand jury presentment so that prosecutors have the ability to pursue capital punishment if they're convinced that he was the one who murdered Madeline. I'm also hoping, based on the evidence that I've seen so far, that mom, Jennifer Soto, gets hit with some charges too. Watching her interviews, my blood is boiling. This lady had a duty not only to protect her child, but also to be truthful when police spoke to her after her daughter suddenly vanished. I say pants on fire, Jennifer Soto. I wonder if police have found evidence of a cover-up with her. Her stories are inconsistent. They don't make sense. The details about not dropping Madeline off exactly at the school, but instead by the church next to the school. Yeah, it doesn't make sense. She said, we dropped her off. And then she also said that her filthy creep boyfriend Stearns was the one who dropped Madeline off alone. But police say the drop-off never happened because Madeline was already dead. So where did the homicide happen? Did it happen in the house? Did it happen behind closed doors where police say the sex abuse happened? That precious child deserved to live. And if her own mother knew what police say was going on with the sexual abuse being carried out by her boyfriend, sicko Stearns, and did nothing to stop it, then Jennifer Soto has blood on her hands too. That's my opening statement. As you can see, I'm fired up on this Thursday morning. Let me know if you like it. Right now, my friends, I want to give you what's on your daily docket.
Were you aware of any connection that the defendant had with Dean and Christine?
Yes.
What was that connection?
He was taking care of their property when they were out of town.
What business did you know Dean and Christine to be in?
I knew that they sold drugs.
All right, my friends, here's a look at the cases we're following for you today on Court TV. In New Hampshire, testimony resumes at 10 a.m. in the small town secrets murder case. In Wisconsin, defendant Jesse Vang, the boyfriend in the Elijah Vu case? Well, he's due in court at 11:30 a.m. He's got a prelim on his child neglect charges. We'll talk about that. And in Alabama, Carlee Russell. You remember that name, right? The woman who faked her own abduction? Well, she's going to court today at 2 p.m. for a plea hearing. So for more on the small town secrets murder case, we want to bring in Court TV crime and justice correspondent Matt Johnson, who's live in the studio with me. Good morning, my friend.
Hey, good morning, Julie. Will the so-called boogeyman take the stand today that we've heard so much about in the murder trial that rocked a small town in New Hampshire? That's what the defense called the known drug dealer, Dean Smornick, during their opening statements. He was the boyfriend of one of the victims and owner of the murder house and was out of town, coincidentally, at the time of the murders. Defendant Timothy Verrill worked for him in the drug business and is accused of killing Christine Sullivan and Jenna Pellegrini back in 2017. Prosecutors say he was high on meth and believe that they were working as police informants. Yesterday, several police investigators took the stand, and a friend of Christine who testified Timothy was angry and on drugs around the time of the murders and complained about, quote, dark thoughts. But on cross, she testified she never felt uncomfortable around him.
During that interaction as well, did the defendant say anything to you about the types of thoughts he was having?
That's in the car when we were driving home. He said that he needed to get off of everything because he was having some dark thoughts.
Dean told you directly that he wanted to kill her.
I mean, he's yeah, I'm going to kill her. I'm going to want to, you know, sometimes I want to kill her, that type of thing.
And she would tell you that, too, that she said that.
Yes.
And you didn't know whether to take it serious or not.
I mean, I didn't take it serious.
And today, day 3 of testimony, we expect more from the state investigator Stephan Johnson about surveillance video that could be key for this case. So far, the defendant has been wearing sweaters each and every day as his defense tries to paint him as a man not capable of pulling off those 2 murders, Julie.
We'll see what happens. Did police get the right guy? That is the question. Matt Johnson, thank you so much for following this one for us. We'll see you later today on Court TV Live. We want to turn now to Tennessee, where the search continues this morning for missing college student Riley Strain. He vanished 2 weeks ago after being kicked out of Luke Bryan's bar in Nashville. His family and the community have been searching endlessly for him, including a search of the Cheatham Dam, and still no signs of Riley. But despite that, officials say they are not giving up hope.
We are going to continue to pray as a group and as individuals that the Lord leads us to him and helps us find him, bring him home to his family.
I have 2 great guests joining me now. Retired FBI Special Agent Jennifer Coffindaffer and trial attorney and law professor Dante Mills. Good morning to you both. Jennifer, I'd like to start with you, please. Many people are crediting some TikTokers and online sleuths for digging up some clues. We know, though, law enforcement has also been searching endlessly as well. Your reactions to how there's somewhat of a battle over who is doing the most here?
Well, certainly, and good morning, Julie. Certainly, the Metro Police Department in Nashville, they're strapped. Look, this is spring break weekend for thousands of kids, and they're going there. And it's a lot to maintain your normal caseload and then have something this monstrous come up in terms of searching. So clearly they did not conduct what normally happens, and that is a grid search. And I think it's because they were actually looking for body rather than for evidence. So it's a good thing, I think, Julie, that all these volunteers are out there searching.
Right, Jennifer. Dante, to you, please, on a legal question. I know there's been a lot of talk about whether Luke Bryan's bar could face any civil liability here. Would you speak to that, please?
Yes, good morning, Julie. This case is captivating a lot of people around the country because he did just disappear after leaving a bar, being visibly intoxicated in that bar, kicking him out. So the question is, could the bar be at fault? Normally, and in Tennessee specifically, there's rules that state if there's injury that happens, it's on the intoxicated person, not the place that sells them the alcohol. There is an exception to that. It's called Dram Shop, the Dram Shop Act. What that is it's a statute that allows, in civil cases, people that are injured by intoxicated people to sue the place that served them alcohol. Fun fact, it's called the dram shop case or law because taverns used to serve alcohol in measures of drams. So you would get 2 drams of whiskey or 2 drams of rum. And that's why it's called the Dram Shop Act. But only third parties can sue the bar. So if you injure yourself or if you're injured by yourself after being intoxicated, you can't sue the bar. It's only if you injure someone else. Then they can point to the bar and say, you saw that the person was visibly intoxicated, but you continue to sell them alcohol, or you allow them to leave the premises, they injured someone else and you're at fault. So in this case, it wouldn't apply. The intoxicated person is going to be the one responsible for his own actions.
Professor Mills, thank you for that. I have a clip I want to play next. This was from our show yesterday morning where a podcaster named Pascal Boboff, who is following this case, he does a lot of different news coverage, not necessarily all true crime, but he's really been digging into the Riley Strain case. And he came on the show. We wanted to ask him about the interview he did with one of Riley's friends. And he gave us some information that we hadn't previously heard yet. And so, Jennifer, I'd love to come to you on the other side of this clip. Let's take a listen together now.
There's been also other accounts of another homeless man allegedly wearing his shirt. There's been claims about that within Old Tent City as well. Some other people that have seen this homeless man wearing his shirt. So yeah, there's been so many pieces of information that have been given from Old Tent City, from other eyewitnesses as well, that yeah, it feels like there could have been some real commotion going on.
Jennifer, our ears perked up as soon as Pascal said that, because we knew that there were identifications made from members of these 2 homeless camps, but we had yet to hear anybody say they thought that Riley's shirt that he had on that night was seen on someone else at one of the camps. So what does that tell you, please, being an investigator?
Yeah, absolutely, Julie. So yeah, I dug into this morning, and this is where this stems from. There's essentially a homeless man that has been identified by police. They know who he is, and he's the individual that was supposedly seen by other homeless people wearing the shirt. His stature was about 5'8", so a 6'5", 6" person. The shirt apparently really hung on him. Supposedly, this individual found this shirt hanging on a post with vomit on it. It was washed off and he donned it. What's interesting is, according to all this hearsay, it was found much further down the river, a place where Riley could probably have not walked to because of the distance. So what I gleaned from this is, first of all, it's hearsay upon hearsay. And so, but normally with hearsay, Julie, there's a little bit of truth in it. So did he take off that shirt because it had vomit on it, possibly, and was that found by a homeless person?
Oh, I knew you'd have great information on this, Jennifer. Thank you for that. Dante, to you next, please. Would you take us home on an important issue pertaining to Riley's parents? They are distraught, understandably so. And if you were their family attorney representing them, tell us, please, what advice you would give to them at this time.
To keep his name in as many people's mouths as possible. It's very helpful when even the internet sleuths are looking for clues, because you never know what clue you're going to find. Take, for example, the shirt. And it was supposedly vomit on the shirt. It was washed off. But that's an important clue that can give location, that can help with the search. So what the family should be doing is what they're doing now, speaking about it every chance they get, so that they can keep this in the front of people's minds as other people do descend onto Nashville, because it is spring break. You don't want the attention to go away, because then the search stops and the police are allowed to move on to something else, and maybe Riley is never found. So I think the family is doing their best to keep this on people's minds, keep them talking about it, keep the internet sleuths and the investigators on their toes and actively looking, because that's the best way to find some answers in this case.
Oh, you're absolutely right. Dante Mills, Jennifer Coffindeffer, thank you both for all the information this morning. Of course, any new details we learn about Riley Strain, we will share them with you on Court TV. Before we hit a break, we want to bring you the very latest in the Murdaugh murder saga, as Libby Murdaugh, the mother to convicted killer Alec Murdaugh, dies ahead of his federal crime sentencing. She passed away in hospice care on Tuesday and has been in declining health for many years. As you recall, Murdaugh claimed that he was visiting his mother back in June of 2021, the evening that his wife Maggie and his son Paul were murdered at their family home. Now, of course, a jury determined that Murdaugh was the real killer and that the trip to his mother's house was just an attempt to create an alibi. Murdaugh will be sentenced on April 1st for his financial crimes, and of course, we'll continue bringing you updates on this case as they are available. Here's what we have for you coming up next here on Opening Statements.
I'm so high right now, y'all. I'm about to go to sleep on y'all. I ain't gonna tell you no lie.
Oh, my. A witness in the young thug Rico case shows up to court high as a kite. We're wondering, how did this guy make it onto the stand? And we've got the latest in the Karen Reed controversy as we're breaking down Wednesday's big hearing, full of surprises with so many people who the defense is accusing, saying, we have nothing to hide, no objection. We'll be right back. Drug ring, a double murder, and deadly secrets in a small town.
Prosecutors allege Timothy Verrill killed 2 women because he believed they were working as police informants.
The Small Town Secrets murder trial, today on Court TV.
There's no way, Logan. I could never come up with this.
We're moving closer to the trial in the case against Chad Daybell.
Prosecutors say they will seek the death penalty.
It's the doomsday prophet, Chad Daybell, on trial.
Now for what's trending in true crime, a prosecution witness in the young thug Rico case in Atlanta, Georgia, recently told the court he was too high to testify.
The authorities, the police, the prosecutors, I just made it broad that they forced Jeffrey Williams into it. Did you hear you say that?
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all. I ain't gonna tell you no lie.
So that was Adrian Bean about to go to sleep. He's an alleged getaway driver for YSL, the alleged gang that stands for Young Slime Life, Young Stoner Life. It's also Thug's record label. And this guy was on the stand on Tuesday. Mr. Bean had been on the stand for several days up until this moment, maintaining that he doesn't remember anything about a robbery that allegedly involved the Grammy Award-winning rapper Young Thug, who you see there on the right of your screen. So we're wondering this morning, how did this guy ever make it to the witness stand? Let's bring in our guests, retired FBI Special Agent Jennifer Coffindaffer, attorney and law professor Dante Mills, and criminal defense attorney and former prosecutor Michael J. Brown. Great to have you all as our power panel on this one. You know, we mean this in more ways than one. I mean, how did this guy literally make it onto the stand being so high? And then also, didn't somebody notice, didn't somebody on that team of prosecutors say, you know what, maybe we should vet this guy this morning a little better than this before he gets on the stand and says he's going to sleep? Ladies first, Jennifer Coffindaffer, would you start us off, please?
Well, it is truly an embarrassment, and I have to say, working gang cases, unfortunately, the individuals that are often the witnesses have an addiction problem. Their whole life exists with waking up in the morning and getting high and staying high until they go to bed. And that is just a fact. And you're seeing it right here before your eyes. I think the prosecution should have recognized that and not let him on the stand.
Right. I mean, they put this guy before the jury. Michael J. Brown, you were once a prosecutor, and can you imagine the embarrassment? Like Jennifer said, it's their witness, their burden, and look what happens. Your thoughts, Michael?
Julie, I think prosecutors know what they're doing, and they know how this is going to turn out. They do this in jury selection. They set it up with the jury saying, hey, we don't pick our witnesses. We don't have to like them. You don't have to like them, but we're going to put evidence before you. There's 2 goals I think they try to accomplish. Number one is they get him to admit he knows nothing. So that precludes the defense from utilizing him as a favorable witness. And there's also this undertone, which they're going to insinuate, they can't come out and say it, which is This is the defendant's buddy. So as bad as he is, the defendant is one and the same. So they try to insinuate that without stepping over the line because it could be reversible error. But I think the prosecution fully knows what they're doing when they put a witness like this on the stand.
Michael, appreciate it. Great points. Dante, would you help us out and give the counterpoints, if you would, from the defense perspective? We've got a lot of defense attorneys sitting there, and this could be helpful, could it not be, to all of their cases potentially?
Absolutely. As a defense attorney, I'm looking at this, and obviously my argument is going to be you can't believe anything that this guy says, that the prosecution is desperate and they will put anybody before you to try and get a conviction. They don't have any credible witnesses. You have to be convinced beyond a reasonable doubt. And are you going to do that with witnesses like this? So I'm going to make this witness the highlight of their case and say, this is the person that they wanted you to believe. He was high when he testified to you, so you can't. And he was the best witness that they had, right? So you make him the standard for the entire prosecution's case and try to make their case look as sloppy as this witness did when he requested water and said that he was so high right now that he wasn't going to say anything. So this is an issue for the prosecution. You know, they did call this person. I know he was on the stand for a few days, so you have to hope that he shows up for court every day in a condition to testify. Unfortunately for them, he didn't. And they couldn't say, Judge, our witness is high today, so can we call him tomorrow? They had to continue with the testimony, and this is what they got, and I think it's a problem.
Right. Great points, Dante. We understand this is the longest running case in Atlanta history. I feel so sorry for these jurors. We'll leave it there for now because we've got some other big trending news we want to get to with our power panel. Let's talk about Carlee Russell. Do you remember that name? The Alabama woman who faked her own kidnapping? Well, she is due in court today for what's scheduled as a plea hearing. You might remember she disappeared after calling 911 saying she saw a toddler walking along the highway.
Hi, I am on Interstate 459, and there is a kid just walking by themselves. Hold on, where on 459 are you? I'm right next to the exit.
Russell returned home 2 nights later on July 15th. This was in 2023, and she initially pleaded not guilty, but a municipal court judge convicted her of false reporting last October. She then appealed that decision in order to get a jury trial. She has yet to say where she was during her disappearance. I think the public court of opinion is wondering about that. And the first judge in the case wanted her to do a year in jail and then pay a 5-figure fine. If she pleads guilty, we're wondering this morning what punishment would fit the crime. Let's go back to Agent Jennifer Coffin. After tapping into your experience with kidnapping cases, this was not a kidnapping case. This was first believed. Now, what do you think would be appropriate for Carlee Russell, and why, please?
I think appropriate sentence would be a year and a 5-digit fine, and this is why. Over $60,000 the public gave of their own money. Hopefully they got most of that back, but that was part of the public outpouring. As far as the law enforcement outpouring, you had city, county, state, the FBI, the Secret Service, all that gave precious man hours, precious time, and all of their resources to find her. That's tens of thousands of dollars that could have been used for another purpose. Carlee needs to be held responsible, and she needs to be a lesson to anyone else who would pull such a hoax.
Definitely, Jennifer. Michael J. Brown, to you next, please. And I hope you don't mind this morning. I'm really tapping into your experience serving as a prosecutor. Curious what you think would be most important to the state in coming up with some type of a sentence that would be appropriate if she pleads.
Yeah, I do think that jail should be a component. You know, in addition to the financial aspect, you're talking about all these resources, manpower, that were diverted towards the search. And you know, Mr. Smith could have been having a heart attack, and Aunt Tilly could have needed the services for something in her house. So you're diverting all these resources to this young lady and her false allegations, and that's really bad. I think the proper type of sentence would be a combination of some jail for the shock value, as well as probation, because there's something underlying her issues, I think, and I think a community supervision would be appropriate as well.
Definitely. Great points, Michael. From the defense perspective, Dante Mills, do me a favor, put on your defense hat. And here, looking at this young woman, the fact that really it was a victimless crime, sort of. We know, as Jennifer pointed out, there's restitution involved. Certainly, that's fair. Thank goodness no one was harmed. Tell me what you think would be most appropriate with her. Would you be really interested in a mental health component to the sentence as well? I keep thinking there has to be something that was going on with this young lady.
Absolutely, Julie. You always hit the nail right on the head. That's why you're so good at what you do. That's exactly where I was going. If I'm representing her, I'm highlighting that she has some mental issues. She has to, in order to put this out there, to make that call. Supposedly she was having some issues with her significant other at the time, and this was her cry for help. And I'm asking the court not to punish her for crying out for help, but to instruct her or give her someone that can instruct her how to cry out in the future when she needs help. And that will be mental health care. You know, whether it's even if she's on probation and has to go for some services while she's on probation, I don't think putting her in jail, that's what my argument would be beneficial to her. It doesn't serve the public any. She's not going to learn anything being around criminals in jail. She will learn if she's on probation and she has to go for mental health evaluations and some treatment while she's home so that she can better learn how to cope when she's in stressful situations.
Right. I appreciate that, Professor. Yeah, you know, that is something that I think it's important for our viewers who love learning about all of this to know that when you are in probation, the court at least has control over that. You know, once the probation period ends, you all know this, then defendants will do what they will do, but at least for a time being, she'll be forced to comply with that treatment, as you said, Dante. We've got to leave it there for now, but today she will be back in court. Carlee Russell, 2 p.m. We'll let you know what happens then. Got to say a big thank you to attorney and law professor Dante Mills for his expertise this morning. We've got to let you get off to court, Dante. Thank you kindly. And Jennifer and Michael are going to stick around with us as we continue here on opening statements. Here is what's coming up next.
We're not going to rest until we get to the bottom of exactly who's behind this cover-up, because not only Karen Reed deserves this, John O'Keefe deserves this.
So Karen Reed's defense team has done a lot of talking, claiming she's the victim, pointing fingers at several other people, and these people are saying, we have nothing to hide. We will gladly show you the records we have if the court finds it appropriate. We're going to dig into that motions hearing where we expected fireworks and we heard things like no objection. And when we continue, we're going to have a deep dive into the case of this little precious angel, Elijah Vu, missing for a month. Today, mom's boyfriend is in court. He wants his bond reduced. We'll talk about that in Tipping the Scales. Have you ever seen anything like this? I sure haven't. This morning, we're highlighting the biggest moments from the hearing for homicide defendant Karen Reed. On Wednesday, both sides appeared in the courtroom, and some third-party attorneys appeared as well to argue motions from her defense team trying to get phone records belonging to people who are not parties to this case, people that the defense team are making part of their legal theory. They're trying to point the finger at people. There isn't really specificity. They're just saying a third-party culprit or culprits in the death of Boston police officer John O'Keefe. Now, Karen Reed's defense team is claiming that she was framed for her boyfriend's murder, but the state says that she hit him with her car when she was very angry at him and very drunk, and that she left him to die in the snow. Now, in response to the defense's motions, and remember, the defense has put forth a lot of very aggressive advocacy here. We've seen them being very aggressive, talking very loudly on the courthouse steps on many occasions. surprisingly, yesterday, there wasn't much objecting from the other side. Brian Albert's attorney, for instance, made it very clear he's the homeowner. He said his client, his wife, his kids, they are not the targets of any federal investigation, and they'd be happy to give up their phone records if the judge says they must do so. Take a listen.
After Brian Albert received a federal grand jury subpoena, Kevin Albert contacted Brian Higgins. Kevin Albert said to Higgins, and I quote, "Look, you went off the grid and Brian doesn't understand. You haven't called him, you haven't checked in on him since these subpoenas go out. Everyone got a subpoena but you." Those were Kevin Albert's words to Brian Higgins. And Your Honor, there's only one way to interpret that. Brian Albert was panicked that that Brian Higgins had flipped on him.
What I want to have the court know is that I have permission to notify the court that Brian Albert, his wife Nicole, his son and are not targets of the federal investigation. And I've been given permission to disclose that in open court.
Okay.
So I think it's important for the court to know that as you go into the motion that you're considering and the arguments from the defense. The third thing I would like to just ask the court is, notwithstanding everything that's just been said and reserving the right to file that written document later on, Brian Albert does not object to turning over the materials that are being requested. I understand that the Commonwealth may be having objections as to the Commonwealth's case, but Brian Albert does not have anything to hide. He does not have anything that he needs to prevent the court from seeing this material. And if the court does deem, after reviewing the material and having access to the federal records, that these are somehow relevant or that these are somehow admissible, and the court deems that Rule 17 has been satisfied, Brian Albert will comply with the court order.
What? So Brian Albert, not a target of the federal investigation, nor is any member of his family. We heard the same thing from Brian Higgins' attorney, the ATF agent, not a target of the federal investigation. If ordered to comply, sure, would be glad to turn them over. Trooper Proctor, this guy, the head of the investigation, no objection to looking into whatever's going on with the internal affairs complaint that's being investigated. His attorney had said, no problem. The Commonwealth saying, we have no problem to these records being turned over from these third parties, as long as you're specific on the date. So here, this is so unbalanced. You have the defense fighting cover up, and these people are saying, no, we think we have privacy rights, sure, but if the court says it's appropriate to turn them over, we will. I've got two brilliant ladies on the program this morning to help me talk about this. I want to bring them in now. Retired FBI Special Agent Jennifer Coffindaffer still with us, and want to welcome in Boston attorney and law professor Wendy Murphy. Good morning to you both. I want to know if you both were as surprised as I was. Wendy, let me go to you. Being an attorney, I'm expecting fireworks galore. I was expecting such a battle. And then when the first thing I heard with Trooper Proctor, who this defense team has tried to crucify, you know, when the lawyer conveyed to the Commonwealth, we don't have any objection, go ahead and look, I thought, oh boy, are things unraveling with this defense theory. What do you say, Wendy?
Yeah, it's such an interesting development, because this Rule 17 in Massachusetts is one of the most generous. If you're a defense attorney, it's really quite broad, meaning you can use it as a defense attorney to demand access to private third-party material. Sometimes it's for medical records of a victim, sometimes it's for therapy records, pharmacy records, phone records. So it's used all the time, but 99% of those instances are unproductive, which is to say, you know, it's more of an intimidation tactic. Oh, I'm going to go snooping through their phone records and find out they were having an affair with someone, and then I'm going to say, you better not testify, or I'm going to bring up this juicy dirt I found in your phone records. In other words, it's rarely ever about the case. It is used quite often as an intimidation tactic because it gives the defense leverage against potential witnesses. So why I was so delighted to see how the Rule 17 thing fell out yesterday, if you will, was that there was no real objection, meaning the defense very much wanted there to be an objection. The defense wanted these witnesses to say, I don't want anyone to see my phone records. They're private. It's a very sensitive thing. You know, I might have talked to my doctor. I might have spoken to my wife about sexual things. This is very private stuff. I object to the defense seeing any of this. And they would have had a right under Rule 17 and under the United States Constitution to make that argument. But what was genius about what the witnesses did was they said, we don't care what you see. We don't care if you get access to our phone records. And that took all the air out of the defense balloon around this conspiracy theory. Guess why? If these people were conspiring, they would have been talking about it through their phones ad nauseum from the minute John O'Keefe was killed up to and including perhaps, you know, the present day, because nobody expects their phone records to be successfully subpoenaed, right? This is devastating for the defense theory that there was a conspiracy. No one supports that theory.
Professor Wendy, everything you're saying, I'm with you. I couldn't agree more. It's funny, I have it in my show notes that the way I was describing to my show team was it went over like a lead balloon. And when you said the word balloon there, it took the air out. We certainly think alike on this. This was not what I expected. It was very unbalanced. It was like the defense was screaming about this investigation, this federal investigation, and there's corruption and a cover-up and all this, and then you're hearing all these attorneys getting up there saying, my client's not a target, my client's not a target. Jennifer Coffindaffer, I'm wondering this morning, my biggest question is, well, who is the target of the federal investigation? Your thoughts on that, please.
Well, I think clearly they were trying to look at DA Morrissey, you know, and how he handled this, because in Massachusetts, when there's a homicide, the state police take over, but certainly he oversees that from a prosecutorial standpoint. And there were fingers being pointed at how it was being handled. So I want to say, though, Wendy put a bow on it. Every thought I had written down, she summarized so well. But I also want to say this. These were good friends. Brian Higgins and Brian Albert went to a funeral that day. They were very close, very tight friends, one being a Boston police officer, the other being an ATF agent. They go way back. It makes sense that there will be some communications between them. Of course, these all were friends. I am so glad they just gave it up and just put a hole in the balloon.
Right, Jennifer. Yeah, that's important to know. These are friends. They work in law enforcement. They're going to be talking. I've got a clip from Brian Higgins' attorney talking about the kind of guy that he is. And remember, just a little reminder, my friends at home, Higgins is the guy that was communicating with Karen Reed prior to John O'Keefe's death. He's the one that, he said that she kissed him, kind of blindsided him with a kiss when he was at O'Keefe's house. So let's watch a little bit of what his attorney said about him yesterday morning.
Brian has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a congressional medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq. Participating in a cover-up is contrary to who he is as a human being and a professional.
Because you have a really decorated officer. And we also have what the prosecution calls a romantic entanglement with Karen Reed. Wendy, back to you. And we're going to show it on the screen. We pulled a little piece of the state's motion in opposition to the motion to dismiss, where to the grand jury, so many witnesses testified for this grand jury who indicted Karen Reed. He claims he was going to the front door of the O'Keefe home to exit when she decided to go with him and shocked him with that kiss on the lips. The two of them were texting. So yesterday, I was kind of just thinking to myself, as Karen Reed's defense counsel was saying, we got to get the phone records of Brian Higgins, and there's really no pushback. Well, we're going to see more about these communications with his client, aren't we?
Yeah, I'm sure some of these things are probably going to be released. The point is that no one's afraid of them being released. And I think Karen Reed knows that Brian Higgins' phone records aren't going to help her, nor do they make her look good. I mean, I don't know what they were doing back and forth with each other, if there's something sexual involved there, but I suspect Karen Reed really doesn't think Higgins has much to offer her. It's so crazy to me. She's trying to kiss the guy, have an affair with the guy, and she thinks somehow he then became involved in the conspiracy. It gets crazier as time goes on. These records are not going to help her. They might well hurt her because she, it's going to show, was cheating on John O'Keefe. That's not good for her.
Not at all. Boy, oh boy, the more information we learn, it seems to me really there may be a big shift coming in this case. My eyes are wide open on this one. So great having you both on to discuss these points. We'll continue talking more in the coming weeks as the next hearing for defendant Karen Reed is next Tuesday. Guests Wendy Murphy and Jennifer Coffindeffer, thank you both very much. When we come back, we'll look ahead to today's hearing for the boyfriend of the mother of Elijah Vu. Drug ring, a double murder, and deadly secrets in a small town.
Prosecutors allege Timothy Verrill killed 2 women because he believed they were working as police informants.
The Small Town Secrets murder trial, today on Court TV. Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, Saturday morning, 10/9 Central, only on Court TV.
This is Wisconsin's toddler now. Everybody in Wisconsin is pretty much taking this toddler under their wing, and we want to just envelope him with protection and get him back where he belongs.
Keep searching. Don't give up.
Yeah.
Don't give up hope on a little child.
Now for what's tipping the scales in the investigation into the disappearance of 3-year-old Elijah Vu. His mother's boyfriend will be in court this morning on a charge of chronic child neglect. He wants his bond reduced. Jesse Vang and Katrina Bauer were arrested shortly after little Elijah was reported missing last month. And we know Vang was the last person to see Elijah. He says he took a nap, woke up, and the toddler was gone. Well, according to local news outlets, Vang has a lengthy rap sheet, and Mom would reportedly send her son to Vang's apartment to be disciplined, knowing full well of the alleged neglect in Vang's care. So Katrina Bauer, the mom, and Jesse Vang, the boyfriend, have been ordered to have no contact with each other or any children under the age of 18. So this morning, I'm wondering, who might start talking first? We have a great guest standing by with us. He does criminal defense work in the private sector. He's a high-profile attorney. He also has experience being a prosecutor. Michael J. Brown is with us this morning. Michael, tell me, looking at mom and looking at boyfriend and the facts as you know them this morning, who do you think might start speaking to investigators?
Point, Julie, that the mother will flip, that the attorney will convince the mother to flip. We all have this bias that it's the man who was really involved in the beating. And in this case, it appears as though he was the one who was responsible for a lot of the actions. So I would suspect, and if I was her attorney, I would do my best to say, hey, here's your opportunity to help yourself and help the authorities. If he's the culprit, you certainly should assist them and help yourself. So I would suspect he's the one. You got to remember that the prosecution doesn't want the worst player to be the one to cooperate. They're always looking to move up the chain, as you know. So I think conventional wisdom will say that the mother is lower down on the chain.
That's an excellent point, Michael. Tell me, we know that today Mr. Vang's going to try to get a significant bond reduction. Do you think this guy has any prayer of getting out of jail this afternoon?
0.0. I think that, I think, and it's similar to cases we have here in Suffolk County currently pending with body parts, and everybody assumes that those people are the ones who murdered this poor lady and man. I think in this instance, again, everybody's assuming, and you need proof, but everybody's assuming that they're responsible for the murder, and they're holding them on the charge of the neglect now. There's no likelihood, in my opinion, that a judge is going to let them get out and possibly flee with the understanding or potential that a murder indictment will come forward.
Right, and so I'm assuming you think what law enforcement has done here has been really smart, getting them on some lower level charges as they continue the investigation into Elijah's disappearance.
Yeah, absolutely. They obviously, if they had enough evidence, they would have charged him with the murder. They have enough evidence to charge him with the neglect. They're holding them with that. And a case like this, where everybody out Everybody out there is looking for proof and evidence and clues. They're going to have a lot of leads coming forward, and I think in the near future we'll see something come down.
You're right, they sure are. We all hope little Elijah is found. Michael J. Brown, wonderful to have you on the program. Thank you for your time and expertise this morning. That is all for this episode of Opening Statements, my friends. When we come back, we're going into Court TV Live. I'm coming with you. We're going to the Small Town Secrets murder case.